Hello everyone and welcome to today's edition of the Daf Yomi from sunny Manchester. Hope everyone is doing well today and let's get started. So, Bava Kamma Daf 72 Amud B. As if it entered your mind that it's prohibited by Torah, the Mishnah here would be difficult, for as soon as he slaughtered the animal a bit, at the very start of the slaughter, he has prohibited the animal with regard to deriving benefit, as a non-sacred animal slaughtered in the temple courtyard. When he slaughters the other part, it is already prohibited with regard to deriving benefit, which means that it is not an animal that belongs to its owner and that he slaughters. Rav son of Bava said to Rav Havivi, it is possible to explain the Mishnah even according to the opinion that the halachic ramifications of slaughtering are in effect throughout the slaughter. And even if one maintains that it's prohibited by Torah to benefit from a non-sacred animal slaughtered in the temple, as when does the thief become obligated to pay the fourfold or fivefold payment as well? It is when he performed that bit of slaughter in the beginning, before the animal becomes forbidden. Rav Ashi said to Rav Huna, do not dismiss Rav Havivi's suggestion with his explanation. In the verse, if a man steals an ox or sheep and slaughters in Exodus 21:37 indicates that in order to impose liability to pay the fourfold or fivefold payment, we require that the thief slaughtered it completely, and after having slaughtered it just a bit, there is no complete slaughter yet. Rav Huna said to Rav Ashi, but if you are correct, the mission is difficult. Rav Ashi said to Rav Huna, this is what Rav Gamda said in the name of Avo. When does the Mishnah state that the thief is obligated to pay the fourfold or fivefold payment? It is in a case where the thief slaughtered part of the Samanim outside the temple and finished slaughtering them inside the temple. Therefore, the animal became prohibited with regard to deriving benefit only in the final stage of slaughter, concomitant with the liability to pay the fourfold or fivefold payment. If one stole an ox or sheep, as established based on the testimony of two witnesses, let's see that in the notes. As the Gemara establishes, this must be referring to a case where the witnesses testified about the theft of the animal and its slaughter or sale at the same time, and that the testimonies about both matters were qualified together. The reason that if the testimony concerning the theft was to qualify first, the testimony concerning the slaughter or sale would be of no consequence, and therefore the witnesses would not be subject to the punishment of conspiring witnesses for the testimony about the slaughter or sale. These witnesses would pay only the double payment. One stole based on testimony of two witnesses. If two witnesses testify that one stole an animal and slaughtered or sold it, the witnesses are found to be conspiring witnesses. They pay everything, including the fourfold or fivefold payment. I'm saying for Shevdim Hechad Eidah 21:6. And he subsequently slaughtered the animal or sold it, also based on the testimony of the same witnesses, and these witnesses are found to be conspiring witnesses. In Zomamim, when two sets of witnesses provide contradictory testimony, both testimonies are completely discarded. As it's possible to determine which is true. Nevertheless, the Torah writes, if an unrighteous witness rises up against any man to bear unto witness against him, then the judges shall inquire diligently, and behold, if the witness is a false witness, and testifies falsely against his brother, then he should do to him as he conspired to do to his brother. Deuteronomy 19:16-19. This demonstrates that there are situations in which it is possible to rule on which of two contradictory testimonies is true and which is false. So to conclude that the situation arises when a first set of witnesses testify that they witnessed an event, and a second set testifies that the first one could not possibly have witnessed that event, as they were in a different place when the event purportedly occurred. In this case, only the second testimony is definitely accepted while the first is rejected. The first witnesses, who are known as conspiring witnesses, receive the same punishment as they conspire to impose upon the victim of their testimony, whether it is corporal or monetary punishment, or even the death penalty. These witnesses pay everything, i.e. not only the principal, but the fourfold or fivefold payment. This is according to the Torah's decree with regard to conspiring witnesses. You should do to him as he conspired to do to his brother in Deuteronomy 19:19. Since these witnesses attempted to obligate the other thief to pay the fourfold or fivefold payment, they themselves must pay that full amount. With regard to one who stole an ox or sheep, as established based on the testimony of two witnesses, and he subsequently slaughtered the animal or sold it, based on the testimony of two other witnesses, If two witnesses testify that one stole an animal and two other testified that he slaughtered or sold it, and both of the witnesses were found to be conspiring witnesses, those who testified to the thief pay the double payment to the one they accuse, while those who testified concerning the slaughter or sale pay him the remaining twofold or threefold payment. They were shown in Hilchot Eidah 21:6. If both these witnesses and those witnesses were found to be conspiring witnesses, the first of the witnesses testified about the theft of the animal, paid the alleged thief the double payment. The Yishim Talmud discusses the case where the witnesses concerning the slaughter testified first, and their account was rejected as irrelevant due to the lack of testimony concerning the theft. Later witnesses arrived to testify about the theft, and they were informed that their testimony would be joined with the first testimony concerning the slaughter. In this case, the testimony concerning the theft led to the imposition of the entire payment. If the witnesses in the second set are found to be conspiring witnesses, they pay the full sum, which is what they conspired to cause him to pay. And the last of the witnesses, who attested to the slaughter or sale of the animal, pay the alleged theft of twofold payment for a sheep or threefold payment for an ox, which they conspired to cause him to pay over and above the double payment. If only the witnesses in the last set are found to be conspiring witnesses. If two witnesses testified that one stole an animal and two others testified that he sold or slaughtered it, and the witnesses in the second set are found to be conspiring witnesses, the thief pays the double payment and the second set of witnesses pay the thief the remainder of the fourfold or fivefold payment, i.e. a twofold or threefold payment. And the thief was shown in Hilchot Eidah 21:6. The second testimony is nullified. Bakla Eidah Shania. The witness who has rendered a conspiring witness is not subject to monetary payment. A conspiring witness is subject to punishment only if all members of that set of witnesses are found to be conspiring witnesses, Rashi, as it was not submitted by two valid witnesses, whereas the first testimony remains intact. If one individual from the first set of witnesses is found to be a conspiring witness, if two witnesses testify that one stole an animal, so that's wrong. One from the first set of witnesses is found to be a conspiring witness, etc. If two witnesses testify that someone stole an animal and two others testify that he slaughtered it, the one witness from the first set of witnesses is found to be a conspiring witness, the entire testimony is nullified. The reason if there is no established theft, there can be no liability for selling or slaughtering. I'm say for Shoftim Hilchot Eidah 21:6. The entire testimony concerning the thief is nullified. If the reason is that if there is no theft established by reliable testimony, there is no liability for slaughtering the animal, and there is no liability for selling it. One who is rendered a conspiring witness is barred from providing testimony in the future. The Gemara says the fundamental dispute with regard to this disqualification. It was stated concerning a conspiring witness. Abai says he is disqualified retroactively when he provided his testimony. Any testimony he may have provided after that point in time is retroactively nullified. However, says he is disqualified only from that point forward, i.e. from when he was established to be a conspiring witness, but not retroactively from when he provided his testimony. The Gemara explains the reasons for the two different opinions. Abai says that he is disqualified retroactively because it's from that time that when he testified that he is considered a wicked man, and the Torah said, "Do not put your hand with the wicked to be an unrighteous witness." Verse 21, which is interpreted to mean, do not allow a wicked man to serve as a witness. Bava says that he is disqualified only from that point forward because the disqualification of conspiring witness is a novelty. So what does that mean? Disqualification of conspiring witness is a novelty. The novelty of the halacha of conspiring witness is twofold. First, the witnesses are not merely suspected of lying, but are treated as definite false witnesses. Second, the court does not suspect the second set of witnesses of falsehood, despite the fact that the first witnesses deny their accounts. It is not based on logic. The reason is that this is a case of two witnesses against two other witnesses, in which case neither testimony should be accepted. What did you see that caused you to listen to the second set of witnesses? Testify that the first set were not at the scene of the purported event. You could instead listen to the first set of witnesses who testified to the event and disbelieve the second set. Here the Torah teaches that the statements of the witnesses is always deemed credible, and the first is subject to punishment as conspiring witnesses. Therefore, as the disqualification of the conspiring witnesses is an anomaly, you have the right to disqualify them only from the time of the novelty and onward. This counterintuitive disqualification does not apply retroactively. They are there to say that Rava also holds like Abaye, who says that by rights, conspiring witness should be disqualified retroactively from when he provided his testimony. And here, this is Rava's reason for not disqualifying him retroactively. Thank you for listening and wish you all the best. Bye.